Hello, this is Erick Widman from Passage Immigration Law, and we're very glad that you joined us for our weekly live Q&A. And we've got a number of great questions that I will jump into right away here. Number one, I got my 2-year green card, and then I received an 18-month extension. I got divorced in the process, and then my case was transferred from Manhattan to Albany in New York. And I haven't heard anything since 2020. I need some advice. You certainly have a lot going on, and you don't need the immigration system to be delaying the green card reissuance to get your 10-year green card. That shouldn't take this long. It's been unreasonably long for years like this, and it shouldn't require another 18-month or now 24-month extension, but that is currently what we have to deal with. That's the default right now, due to a backlog with USCIS that's lasted years. But they're supposed to get your 10-year removal of conditions, your green card application for your 10-year green card. They should get all that resolved, in theory, before your extension expires. However, you haven't heard anything since 2020. It's now 2022. And you need proof that you're still a permanent resident, even if USCIS is incredibly slow. So the best way, and one of the few ways to get proof of your permanent resident status while you're waiting for your 10-year green card to arrive, is to set up an InfoPass appointment with USCIS. You have to call them up currently to set that up. You have to navigate multiple layers of the phone tree, ask for an InfoPass appointment, and explain that you have an expired green card, your extension expired, and you need them to give you need to get a green card stamp in your passport. So bring your passport in, and you'll get an I-551 stamp showing that you are in fact a permanent resident, and they'll stamp you for a validity period of another 6 years, hopefully a year. That will then give you formal legal proof that you are a permanent resident. That's good for work, travel. It is an official stamp like a green card and used interchangeably. Follow up with USCIS with an online e-request because your case has likely been delayed beyond standard processing time. So you'll want to do that. And in fact, when you call USCIS to set up the InfoPass appointment, inquire about your delayed case. You will likely be told you just have to wait some more. Then you might seriously consider a mandamus lawsuit for the delay of your case. If it's been over a year beyond standard processing time, that's a general rule of thumb for when you have a reasonable chance of winning because of this unreasonable delay. So that is something to consider too if you're still stuck in limbo and you don't have the 10-year green card. Okay, on to the next question. I filed for citizenship 4 months ago, and I got an I-797C letter. My green card's expiring in 3 months. Can I travel with an expired 10-year green card and your 797C document, which is your official receipt notice from USCIS? So you've been following the rules. You applied for citizenship. You don't have to renew your green card if you apply for citizenship more than 6 months before the expiration date. USCIS says that's fine. However, on a practical level, you want to make sure that when you travel with an expired green card, you'll be able to get back into the US. And I looked this up to double check and make sure. And yes, indeed, you are able to board a plane, come back into the United States with an expired green card. But if you lose your green card, if it's lost or destroyed, you're going to need to get a boarding foil to come back into the United States. And by the way, bring that receipt notice, the 797C receipt notice with you in either case. You'll want to bring the original just in case. We've had clients successfully use a photocopy, but original is always best. And If you have to get a boarding foil, you'll do that at the local embassy, but you're able to board a plane and come back into the US. You might have to explain this to them and print out some rules and regulations. We've often armed our clients with a printout of a policy manual or guidance from the State Department, the FAM, as it's called, Foreign Affairs Manual. So with that type of guidance, print it out. You can show the airline, you can show the folks who are giving you grief, trying to get through into the US. You got to board the airline, and then, of course, you have to get through CBP and customs. But good news, in your particular circumstance, you should be okay even with an expired green card. Print out that documentation, though. All right, on to the next question. After being granted asylum through the immigration court, does the court submit an I-94? I'm going to need more information about the context for this. So you could email us at support@passage.law and give us more details. And we could email you back to find out exactly what you might need and where you're at in the whole process with your removal defense case. Next question. Hi, I have a question. I filed a Form I-130 petition for my husband, and he, however, had been deported back to Guatemala. I need to see about the process to get him back home with us. Well, I'm very sorry about that. Being separated from your loved ones is a horrible experience. In order to overcome a deportation and provide USCIS and the State Department with the documents they need, you're going to need essentially a waiver. And it's a 212 waiver after someone has been deported. That is one of the requirements, Form 212, and there is a lot of guidance. It can be confusing too. The whole waiver process is tricky, but following deportation, that is a requirement to get that approved in order to move forward with the I-130 petition for your relative. Great to see you. Thank you for checking in. It's a pleasure to meet with you once a week. Keep sending in good questions like these, and I will be happy to answer them. Take care.